Hi, I'm Dion Tracy Duckett, estate planning and elder law attorney with Duckett Law LLC. In this video, I'm talking about probate and estate administration. I've chosen this topic to speak about second is because often people do their estate planning in order to avoid the probate process. So there's two types of probate, living probate and death probate. Generally, when people mention probate, they're talking about death probate. And then when we talk about death probate, we want to distinguish probate from estate administration because basically there's two processes that are both handled by the probate court. So probate is the process when there is a will. So you've done your estate planning, there's a will in place. Often people think that when there's a will, the executor can just take the will and the executor can just take the will and do what it says do. But that's not true. The process is required for the will. The word probate actually means to prove the will. And so when someone dies with a will in place, they're said to have died testate. If they die without a will or an estate plan, they have died intestate. The agent appointed when there is a will is referred to as the executor, and with intestate estate administration, the agent is referred to as the administrator. Both the executor and the administrator can be referred to as the personal representative of the estate. In both, the court process is required. The difference in the two, distributions in probate, where there is a will, distributions are made according to the will. Where there is no will, distributions are made according to the statute. Now, when we talk about living probate, we're talking about guardianship and conservatorship, or more really the conservatorship process, which is living probate for the property. But both of these are also handled by the probate court. So in guardianship, we're talking about guardianship of the person. This occurs when you haven't done planning to designate someone to manage your care, if you're no longer able to manage your care. If the court determines that you don't have the capacity to manage your own care, the court can appoint an agent to do that for you. Under those circumstances, your rights are removed. An agent will be appointed who makes determinations about your care, where you live, health care, treatment, and all other things involving your care. Court supervision is ongoing, and annual reports have to be made about your status. With conservatorship, often referred to as guardianship of the property, it's the same. You haven't put into place any other options for the management of your property or your finances if you become incapacitated. So in that instance, someone has to petition the court to have a conservator appointed. In that circumstance, again, your rights are removed. And now the agent has rights to make the decisions for you and is legally responsible for making decisions for you regarding the management of your property and the management of your finances. Court supervision is ongoing, and typically a bond is required. So when we talk about the probate process, whether it's living probate or death probate, a petition to the court is required. The process is a public process. Once documents have been filed in the court, anybody can go and pull them unless the documents have been sealed. Notice is required to go into the paper, and of course, that is a public process. Then there's cost involved. There's court costs, publication costs. If we're talking about probate, estate administration, or conservatorship, typically a bond is involved. And all of those things come out of the estate. All of those expenses are paid by the estate. With the estate process, probate or estate administration, sometimes that bond can be waived. But with the conservatorship process, a bond is usually required. And then there's the fiduciary commission. The fiduciary is the agent appointed, whether by you in your will or in your incapacity planning documents or by the court. And usually they're entitled to get paid, and those fees are set by the statute. And then there can often be attorney's fees. So sometimes the probate process can be rather costly. And then there's time. The probate process, probate and estate administration, when no one is fighting or contesting the process, on average takes a year and a half. It can take as few as 6 to 8 months, and it can take years. If you get into disputes or complex issues, then it can take more than a year and a half. It can take several years. And that's why when it comes to death probate, you want to make sure that you file immediately. If you file years down the road, you'll be in an heirs property, or you could possibly be in an heirs property situation, which can make things very complex. When we're talking about guardianship and conservatorship, there's different types. There's emergency, there's temporary, and there's permanent. And the emergency can take a few days. The temporary and permanent can take a few months. If people are fighting, it can take longer. Um, and so that's it for an overview of the probate process.